Now there's two other books I want to bring to your attention over here, because one man asked me about the income tax. The income tax is based upon fraud. In 1953, the House Committee made this determination. Arthur Altmeyer was the first Commissioner of Social Security. To this day, Social Security is pitched to you as being insurance. And when you go in to the Social Security office, they tell you that it's insurance. What they don't tell you is that it's social insurance and that there is no property rights to it. Now, when you buy an insurance policy, you know when you die that your wife's going to get paid some money. But when you have Social Security and you die, there's no guarantee that your wife is going to make any money. So, Senator Curtis had this to say. It is apparent that the people of this country have no insurance contract. Got that? Social Security is not an insurance contract. That does not mean that I do not want to do my full part to do justice to them and to carry out and to make good on the moral commitment that has been made to them. Yet, notwithstanding the fact that they had no insurance contract, it remains true that the agency under your direction repeatedly in public statements, by pamphlets and radio addresses and by other means, told the people of this country that they had insurance. In fact, they're still doing that to this day. Now, in Fleming versus Nestor, which was decided by the Supreme Court in 1959, the court said that the Social Security was an insurance scheme. Now, legal definition for a scheme is an unlawful activity, except that Congress created the unlawful activities, such as your lottery. See, a lottery is a numbers racket, and a numbers racket is illegal and unlawful as a definition or by application of law. But you see, when the government does it, well, then that's what gives it its legitimacy. So if the government licenses a whorehouse, that's what gives it its legitimacy. Adultery is still a capital felony, but when the government licenses a criminal activity, then it has its legitimacy as an operation of law. So in the case of Social Security, if you want to drop out of Social Security, you have to allege that there was a fraud. And many people have made their Social Security rescission. But the problem is that if you make a Social Security rescission and you fail to allege the fraud, then the rescission is null and void ab initio. Because the only way out of Social Security is by way of fraud. Because when a contract is entered into, it's presumed that the parties read and understood the terms and conditions of the contract and agreed to them, and your signature is the prima facie evidence of your agreement. So if you're going to come back later and allege or argue that the contract should be set aside, then there's got to be a basis for setting it aside, and the only basis for doing it unilaterally is under fraud, unless your opponent would agree to bilaterally set it aside, which Social Security has never done. So that being the case, then the burden is on you to go forward to show that there was a fraud, and it's Senator Curtis's House subcommittee that proved that in 1953. But let me tell you, that report is buried so far and so deep in the Library of Congress that it took 4 years to ferret it out, even when we knew the date and the time and the place of the hearings and the relevant matters of the testimony. It's the only place left in America, to my knowledge, is the Library of Congress, who has the duty to keep both the Senate and House journals and the congressional reports and all of the Senate committee hearing testimony. Now, they've got those testimonies go clear back into the 1830s and 40s. But when we went to find this one here, let me tell you how rare that is. In fact, it's probably more rare than federal standards for prisons and jails, because federal standards can be brought out under the Freedom of Information Act. But the committee report couldn't even be located under freedom of information. Now, that's how rare it is. I might want to point this out too, that in an income tax defense, in the last 20-some years, up through 1985, from 65 to 85, the Supreme and the Circuit Courts have listened to some 2,000 novel arguments relating to the income tax, such as the 16th Amendment is unconstitutional, or that it wasn't properly ratified, or that I'm not a taxpayer, or that the tax is unconstitutional, on and on it goes. 2,000 of them. 1,997 of them have been termed frivolous. There are only 3 legal defenses to a tax charge. And they are reliance, Aiken, subjective good faith, or First Amendment free exercise. Those are the only 3 legal defenses there are to a tax charge. So if you want to do that on an income tax case.
What's reliance?
Reliance is where you go to an attorney and the attorney says to you, you're not a person who's required to file. Now you pay him money. And then later on you find out that the IRS comes after you and they say, well, yes, you've got to file or you've got to pay. And you find out that you're under prosecution. It's an affirmative defense. You see, the courts have said they don't want to put people in jail because their attorney or their accountant gave them bad advice. You still have to pay the civil penalties and you still got to pay the tax, but there's no jail. Aiken runs along that line. It's called subjective good faith. If you bought an Irwin Schiff book and you truly believed that you weren't a person who was required to file and you didn't file, the courts have said, we don't want to put you in jail. It doesn't mean that you don't have to pay the penalties, that is the civil penalties, but we don't want to put you in jail. And religious free exercise is where the Amish are. An Amish man doesn't have to pay Social Security because he's exempted. So free exercise is the third legitimate defense.
And that's only for Medicare, free exercise?
Free exercise.
Can you become Amish all of a sudden and get out of it, or?
I don't think becoming Amish has much merit. Now, I don't pay an income tax, and I use religious free exercise, but I do it under Public Law 97-280, which is in Statute 96-1211 as it relates to Seeger, as it's construed by Seeger under the First Amendment's free exercise clause. And in my tax class, I'm pretty emphatic about those 3 defenses because, as I pointed out when I told you about the income tax on Friday, that if you walked into court as an attorney and alleged a constitutional defense, you'd be disbarred on the courtroom floor instantly. And there is no constitutional issue attendant to an income tax issue. None. It's always contractual. And it isn't a matter of constitutionality or unconstitutionality. It's extra constitutional. Comes under the Uniform Commercial Code or the Roman Law Merchant. I think I mentioned that to you on Friday. The last book over here that I use for my students, this is lesson 5 of my basic school. It's called Rights of Individuals. I want to point out some of the chapters in here because remember I pointed out to you that some people have rights and some people have privilege. Let me give you an illustration of this and then I'll show you about this book. You could liken Colorado to a mental hospital.
That's pretty good. No, it's bad.
And what you're dealing with here is a warden who's called the governor. And you've got a legislature. This legislature over here is the board of directors. In this institution, there are police. These police are the guards. And then you have inmates. These inmates are called citizens. This is the reality of your dilemma. the question arises, has it always been this way? And if not, how did it get this way? And the answer has to do with this thing of status. There are 24 statuses of persons in the United States. For instance, a corporation is a status of person. An individual is a status of person. A convict, a soldier, all have a certain status. A doctor, a dentist, has a place in your society. This process, this conversion from the common law to the civil law, from common law legal process to the civil law legal process that's commonly called admiralty and equity, began with a case called Delovio versus Boyd in 1815. So I've traced the history of the change that's gone on here in the United States in Lesson 5. Let me give you an illustration of one of the chapters in here, about page 50, which has to do with the bankruptcy of the United States in 1933. Now remember, the Federal Reserve Act came in 1913. 20 years later, 1933, comes the bankruptcy. Now we're right on the verge of the second phase of the bankruptcy of the United States. And this has greater and more far-reaching repercussions than merely a depression. We called the bankruptcy a depression in 1929, but what it really is, it's the transfer of all public property from the states to the Federal Reserve. Listen to this. Also of concern here is the Pennsylvania General Assembly Act 111 of May 12, 1933. This act declared that when the state treasury department could no longer pay its debts and was jeopardizing its depositors and creditors, the Secretary of Banking would be designated as the receiver for the treasury, and he was to file a certificate of possession in Dauphin County's Prothornary's office in Harrisburg, the state capital. As receiver for the state treasury and all of its offices, meaning all of the county treasuries, William D. Gordon, Secretary of Banking, was granted the authority by Act 111 to appoint a fiduciary to manage all of the financial matters of the state. Every state in the Union went bankrupt in 1933. I took two: the Bankruptcy Declaration of California of May 12, 1933, and the Bankruptcy Petition of Pennsylvania, also done on May 12, 1933. Now, most people have heard about the Great Depression, but you didn't understand the legal ramifications of it. What you were witnessing there in 1933 was the transfer of the state capitol building from the possession of the Republic of Pennsylvania to the bank called the Federal Reserve Bank. In other words, the state of Pennsylvania is still using the state capitol building, but the state capitol building is the property of the Federal Reserve Bank. Now, between 1933 and 1993, which is another 60 years, they have not foreclosed on your farms and your businesses. Now, many of them have been foreclosed on, and that's what you're witnessing here, but when this thing comes to a head in the next round, they're going to foreclose on and then take possession of all of the rest of the property in the United States. So this fiduciary to manage the financial affairs of the state was William D. Gordon. William D. Gordon then comes in as the trustee of the bankruptcy, which is exactly what happens here. When you file for bankruptcy, the court appoints a trustee to manage the estate or the property. He also had the power to assign a security for loan contracts from the federal government. All property in the state, real and personal, resources, and many other assets such as insurance to the Federal Reserve. Now that's already an accomplished fact, but there is another accomplished fact which is just about to come down on us. The Great Depression was in reality the bankruptcy of the state and federal governments. The Federal Reserve foreclosed upon all the assets of the government and took possession of all government assets. In HJR 192, the bankrupt federal government called upon all of the citizens as co-signers on the hypothecated maritime loan to turn over all of their gold to the Federal Reserve Bank. So when our grandfathers marched up to the Federal Reserve banks in 1933 and put their gold on the counter, who told them that the government had just declared bankruptcy and that the co-signers on the notes were now required to come in and to pay off on those notes? See, that didn't explain that to you, but that was the legal ramifications of HJR 192, which is already an accomplished fact. The question remains, though, in 1990, is it possible for you and I as individuals to own property and to own that property independently of the Federal Reserve? And the answer is yes, it's still possible, but it isn't going to go on too much longer. And this new constitutional convention, which is being promoted here for the purposes of controlling the federal deficit or the federal budget over here, is going to be used as the ruse to change the Constitution to prohibit the private ownership of property. I think that will come about sometime here in the 1990s. That's what this book called Rights of Individual deals with. It's the change or the shift from the common law to admiralty and where it started, and that's one of the chapters in some of the information. These books up here that I've just gone through, some of them I have. If you'd like some of them, let me know, and I can give them to you today. The others on your list, you'll have to write for those yourself. The question that I started with is, if you started and you wanted to know how many books or what are the names of the key books that a pro se litigant needs, there are 9 of them, and I gave you that list. Let's take another 10-minute break, and we'll be right back.
Good question. You said there are ways of owning your property so that the federal government can't come in and, or the Federal Reserve and glom onto it?
Yeah. And it comes under the old common law, which is called the Law of Moses. The common law makes provision for the private ownership of property, and there are 14 statutes that govern private ownership of property. But as I mentioned to you the other day, we don't participate in private business, we participate in public business, and of course the Federal Reserve is the lender to public business and corporations. And it's for that reason that they're going to foreclose on their notes. And their notes are all pervasive here in the United States. The United States government runs on bonds, and all of the banks run on bonds, all of business runs on bonds, or they have stock certificates out. And the Federal Reserve is the hypothecated owner of all of that property. So when push comes to shove, they're going to foreclose on everything except the private property, of which there's very precious little left in the United States.
Do you teach how to do that?
Yes, we do.
You do? What is that called?
That's the private business and professions class. So business and profession is what you'd be looking for if you want to know how to do private business, which I'll be talking about here in the next hour. I'm going to lay something on you here about private business. Let's take a little break, 10 minutes, and then we'll come back. I'll yell at me when you run out. Are we on? We're plugged in this time? All right, let me give you my name and address for those of you that came in late. I'm George Gordon, and I live at Post Office Box 297 in Isabella, Missouri. Zip code is 65676. And the telephone number is 417-273-4967. And if you haven't filled out one of these blue cards, why don't you give me your name and address, and then turn it over on the back side. Tell me what you're interested in. There's a list of the classes that we covered tomorrow in our seminar. I'll go over these classes and I'll show you how they apply, how to use them in everyday garden variety life today. I'm going to cover a couple of 3 of those topics here this afternoon and show you what I've accomplished. On the inside fly cover of my schedule, every one of you didn't avail yourself of this, and right after we finish today's class, pick up one of my schedules for 1990. It starts off by saying that I don't pay an income tax. I don't have any state license taxes. We don't use the public schools. We don't use the public schools. We don't use chlorinated and fluoridated water. We have no state mandated inoculations, driver's license, car registration, car insurance, credit, loans, debt, business permits, business licenses, no state, county, or local inspections, OSHA or EPA standards, tax forms, government forms to fill out, social security number or taxes to pay. I don't have a marriage license, birth certificate, military occupation, U.S. or state citizenship, U.S. or state residency, no state sales tax to collect, building permits, no government reports to make, and the list could go on and on.
You dropped your mic. How long?
Thank you. That's the list that it's a list of 30 items there that I do or don't practice. And a lot of people ask me, well, my God, how do you do that without going to jail? And the answer is, I don't break any laws. The trick is, you can never break the law. But for every law, there's an exclusion or an exception written into the act to exclude or to accept certain persons for certain reasons. For instance, the act in Missouri starts off with driver's license and says, all persons in the state of Missouri shall have a driver's license, except. Now, the exceptions are, well, what if you're driving a tractor or a piece of off-highway road equipment? So you don't need a driver's license to do that. The federal statutes require that everybody has a social security number. Well, except Mennonites, Amish people, and certain other religious groups that are opposed to social insurance for one reason or another. So the trick is to become good at the exceptions to the laws that you take exception to. If you don't want to practice a particular law, let's take insurance. We have a mandatory insurance law in Missouri. There's a couple of ways that you can get around that. But here's the way I get around it. I looked at the mandatory insurance statute and I said, gee, I don't like that statute, but it applies to me if I was a citizen or a resident of Missouri. What if I was a citizen or a resident of Alabama who happened to be traveling through Missouri? Well, now that law doesn't apply to me. So what a lot of people do is they record or register an automobile in Alabama, which doesn't require insurance, and they maintain a residence in Alabama, which in some states is a requirement, in some states it isn't. Therefore, it leaves them outside of the insurance law, or an exception to the insurance law of Missouri. But there's another way. One time I was driving across Missouri, and a highway patrolman stopped me and he asked me why my license plate was the way it was, and why I didn't have a driver's license, etc. We'll make a long story short, he arrested me, and now we had to go defend. So when we went to trial, leaving the driver's license and registration for a time, when we got to the subject matter of the insurance, this old judge, about 75 years old, his name is Judge Light, he said, now, Mr. Gordon, why don't you have insurance? And I said, because it's against the law. And he says, oh no, Mr. Gordon, you do err. The law of Missouri, and he cited the statute, requires that every person who is a resident of Missouri must have insurance on his automobile. Now we have to take another look at it. So I said, well, Mr. Gordon, let's suppose for the sake of argument that you were driving your car across Missouri and you didn't have any insurance and you had an accident. How would you pay for the damages that you caused? I reached in my pocket. I held it up and I said, with gold. And he said, but Mr. Gordon, let's suppose that you didn't have enough gold to satisfy the damages. Then what would you do? Notice the judge is asking all the right questions. I got to give him all the right answers. So I said, in that case, you would take me over to the doorpost and drill a hole through my right ear and sell me to the aggrieved party under the bondservant statute of Exodus 21:28. Right question, right answer. And he said, but Mr. Gordon, the 13th Amendment is a collateral estoppel to involuntary servitude. See, the judge never lost a beat, did he? Right question, demand a right answer. To which I responded, I agree. The 13th Amendment is a collateral estoppel to involuntary servitude. But it isn't an estoppel to voluntary servitude, and I just volunteered. Right question, right answer. Now what I did here wasn't something that was mysterious. It's called religious free exercise under the First Amendment. You see, I'm a Hebrew and I practice the law of Moses. So when I walk into court, the people of the United States do not practice the law of Moses. They're Christians, basically. 95% of you are. And you people are all under grace. You're not under any law. And you're citizens of the United States, and you are residents of the state in which you reside, and you're subject to the laws of Colorado. Colorado doesn't practice strict liability. Colorado practices limited liability. Now, as citizens of Colorado, your sovereign, the state of Colorado, is your God. Let me show you how this works. A sovereign is a legal term. Queen Elizabeth is a sovereign. The United States is a sovereign. Texas is a sovereign. A sovereign's a lawmaker. Now, a lawmaker is a god. Colorado is God. So when Colorado passes a law and says, thou shalt have limited liability, and you may call this whatever you want, in our state we call it the Financial Responsibility Act. Financial Responsibility Act. I mean, how many of you would like to participate in the Financial Irresponsibility Act? See, that doesn't sell very well. So what we have to do is to sell what it is that people want to buy. Now, people want to buy financial responsibility, but they don't want to be responsible. I mean, you see, if you wanted to be responsible for your actions, then you wouldn't need insurance, would you? Because you see, I'm responsible for my actions. How many of you people in here have auto insurance? How many of you people in here think you're responsible for your actions? You have auto insurance, ma'am? Oh, well, what happened to you? You anti-social deviant? You right-wing radical lunatic fringe? I mean, that's what they call people like us. I'll tell you a little story here. It's kind of funny. It was quite a few years ago now, about 1980. And I was in Jake's bar. My friends and I had a few drinks in the afternoon. And we walked out after dinner, and my friend Colin said, hey, George, you better take a cab home. You're too drunk to drive. And I said, well, I'm too damn drunk to drive. I'm sure as hell too drunk to walk. And I don't think I can cause $500,000 in damages in 16 blocks. So I got in my car and I drove home, and I was right. Didn't cause any damage at all in 16 blocks. But let me tell you that I had a $500,000 insurance policy, and if I'd have killed you, lady, it was no big problem, because I was in safe hands with Stein McMurray. And they would have paid off like a slot machine. Well, after 5 or 10 years, and after you sued them and made them pay, they would have paid you, maybe, some of it. If you were good, you could defeat them. Now, how's that sound? I mean, we all buy insurance, but when you get right down on the bottom line, let's analyze what it really is. You see, you go to Mutual of Omaha and you say, I don't want to be responsible for the damages that I might cause on my way home tonight. And they say, well, you're in luck. We've got an insurance plan over here, and if you'll just pay us $500 a year, we'll give you 200 to 1 odds, a $100,000 policy for $500 a year, then you're not going to have $100,000 worth of damages. So you take 200 people like that, and you all pay your $500 in. This is called limited liability, and whoever has the wreck wins the lottery and collects the funds. That's what the bottom line is. None of you people are responsible for your actions. Mutual of Omaha is. Now, in my case, practicing strict liability, I'm strictly responsible because there's nobody else that I've contracted with to be responsible for my actions. And so when you have a claim against me, the claim is against me, and I can't go to a third party and say, well, go satisfy this guy's claim over here because I've got a contract with you. Now that's the distinction between limited liability and strict liability. A guy came up to me the other day and he said, I was hit by an uninsured motorist. Well, the thing that protects him in Colorado is the 13th Amendment. You see, we used to have slavery in the United States, which is called bondservant status until 1863 when President Lincoln abolished it. Because, you know, you all said slavery is a bad practice and we don't want to do that anymore. So now, when an uninsured motorist runs into you and he causes you a damage, you can't bore a hole through his ear and force him to work that damage off to the year of release or the Jubilee. Because you see, you've abolished that law. Now that law came from Moses and was in effect in the United States as recently as 1860. But that's not my fault, folks. So now your God, the state of Colorado, has said, well then everybody has to participate in the insurance program. Well, in New Jersey, there's a fellow that was in Time magazine just recently, has 3 daughters and a wife with 3 automobiles, and he pays $6,000 a year in auto insurance. And he was kind of complaining. He said, that's too much and I can't afford it, one thing and another. Well, who is this slave to say to his God in New Jersey that he can't afford it? When God speaks, you salute smartly and say, yes, sir. Now, I decided that I didn't like that and I wanted a different remedy. So I've applied a different remedy, but now as a different cat, I have volunteered to be responsible, but your law doesn't make provision for my practice of the negligent statute of Moses. I'm prepared to do it, but your law prohibits it. So I get the benefit without the costs. Now I'm sorry that it works out that way. It's an asset to me and it's a liability to you, but that's the way your lawmaker wrote the law. I didn't write it. Remember, I don't make the rules. I don't make the rules, I don't write the laws. I just apply the law as you people write it, as you people apply it, and I apply it to me and take the benefits. Now let me point out another factor to you that perhaps you hadn't been aware of. I don't have a business license. I don't know if that's offensive to some of you, but it gives me quite a competitive advantage. You see, when you go to compete against me, I have no unemployment insurance to pay, no workman's compensation to pay, no income taxes to pay. In fact, I don't have any insurance to pay. And yet here I am competing with each and every one of you out here in the marketplace. Isn't that tragic? Well, I think you people ought to practice the law that I practice, but then I'm not here to force you to do anything you don't want to do. I just wanted to point out that there's some advantages that come from it, and it's called private business. Now, about 1900, your grandparents, your granddaddy, your great-grandfather, Abe Snow, practiced private business. Now, today, what we call private business isn't really private, it's public. But we call it private. And George Orwell pretty well put his finger on the pulse of the problem, you know, when we look up at the floor and down at the ceiling and speak from the blackboard and write on the podium. Now, if I taught you people that those were the definitions of those terms, we look up at the floor, we walk on the ceiling, we write on the podium and speak from the blackboard, and you know, pretty soon you could follow that and you'd practice that and you'd regurgitate that, and I'd say, would you walk over to the window and let's walk through the we'll look through the door and walk through the window. You'd get up and you'd walk through those doors back there because that's the window. And that's exactly the way the law has been applied, or it's been written in the last 50 or 75 years. I pointed this out with Social Security. When you go to Bouvier's Law Dictionary and look up wages, it's property. And when you go to the Social Security Act, wages are income. Now, income is a profit and gain, which is derived from a privilege, but wages are property, which are derivative of a right. And rights and privileges are 180-degree opposites. So what's happened is Congress just comes along and appropriates a word named wages, because all of you use it every day. You work for wages. And then applied it to a contract and said, for the purposes of this contract, wages shall be construed to be income. Now you walk into court and say, well, my wages are property, and the judge promptly pukes on you and sends you off to Leavenworth for 18 months, and everybody wonders, well, what happened? Well, it's because you didn't understand English. See, you haven't read the terms and conditions of the contract. But there is a legal distinction between public and private business. Here's what they are. Business is said to be clothed with a public interest, which justifies some public regulation, may be divided into three classes. So, there are three classes of business. Now, I want to apply this to George Gordon's everyday life out on Main Street, and I don't want to pay any taxes. I don't want to pay an income tax. I don't want to collect a sales tax. I don't want a sales tax number. And I want to do business, and business is divided into three classes. I didn't write this. The Supreme Court wrote it. So I just want to learn what it is they're applying this to, and then I want to slip through the cracks. I'm going to apply this just exactly the way the lawmaker wrote it up. Those businesses which are carried on under the authority of a public grant of privileges expressly or impliedly imposing the affirmative duty of rendering public service demanded by any member of the public, such as the business of a common carrier or a public utility. So if I'm going to operate a public utility, like a taxi cab, a bus, a truck, or something on that order, then I'm going to be regulated and controlled. So I woke up one day and I said, well, I guess I don't want a taxi cab. And I don't want a public utility. Number two, certain occupations regarded as exceptional, the public interest attaching to which, recognized from earliest times, has survived the period of arbitrary regulation of all trades and callings by Parliament and colonial legislatures, such as inns, cabs, and grist mills. So if you're going to run a hotel like this one or the Holiday Inn, a cab or grist mill or something like that, you're going to be regulated and controlled, and you're going to have your licenses, etc. So I said, well, now I can see what I can't do. Number three, other businesses which have come to have such a peculiar relation to the public that government regulation has been superimposed upon them, where the owner, by devoting his business to the public use, in effect, grants the public an interest in that use, and he subjects himself to regulation to the extent of that interest, such as a restaurant. If you're going to go to Denny's over here, they got a sign out on the street that says, "Welcome to Denny's, credit cards accepted." Now, the distinction between these is that it is the option to deal or to abstain from dealing which distinguishes private from quasi-public occupations. It's the option to deal or to abstain from dealing. All right, so now, whatever it is I want to do, I have to have the capacity to deal or to abstain from dealing. And this is called contract, which is protected at Article 1, Section 10, which prohibits government from impairing the obligation of your contracts. So, if I made a contract with you and we wanted to conduct a business enterprise, let's say under Leviticus 11 or Deuteronomy 14 or Leviticus 19, 35, and 36, and we wrote up a contract to that effect and brought it under the free exercise clause of the First Amendment, as it's construed by Article 1, Section 10, then we would be in private business. And the court goes on to distinguish what it is that causes you to enter or to cross over the line. Anytime you enter trade, commerce, business, or industry, which affects the public interest, you're in public business. So the trick then is for me to deal with people privately under contract, and I have to do so with something other than Federal Reserve notes, because remember I explained the other day, or rather I shouldn't say I explained, but Stanek versus White explains that this note is legal tender for all debts, public and private. This note is legal tender for all public debt. So what I do is I come along and I contract with you and I say I have a school, and for 2.5 ounces of gold I'll put you through my school. And I'm going to contract with you privately in gold, which is property. And I'm not going to affect any trade, commerce, business, or industry that affects a public interest. Only a private interest. So, when you come to my farm, you'll find that there's no signs up on the road that says Gordon School of Common Law. You'll find no advertisements in the yellow pages. You won't find that I advertise anywhere. What I do to sell my product is I conduct private seminars like we're doing here today. And then I go out and I talk to other people, and then I can talk to people under the free exercise clause of the First Amendment and free speech. Now my problem is when I come to speak to a group of people like you, you see, you people are all slaves. Let me ask this question. Don't you all have Social Security numbers?
No.
Well, there's an exception or two, but for practical purposes, you all do, don't you? And you all have birth certificates, marriage licenses, driver's licenses, and you're citizens of the United States, and you're residents of the state of California or one of the several municipalities. Which brings you under this law, this lunatic fringe over here, this insane asylum that I drew for you a moment ago. Remember that? As such, it's like walking up to a penitentiary. And I walk up to the fence. And you people are all inmates in here. And I'm on the outside. And I want you people to break out of this penitentiary. And I'm here to teach you people to escape from this institution called Colorado. What do you think the governor and the legislature and the public officials are going to say? What do you think the warden and the board of directors and the parole board are going to say?
They don't want to lose you.
Hey man, they're going to lock me up for trying to incite an escape. So I have to be very careful about how I talk to you inmates. So I have to come up and say, the warden has said that I can talk to you people based upon free speech, but I cannot incite you people to violate any laws or to escape from the institution. But as a matter of free speech, I can go so far as to say, there is a way for you to extricate yourself from this institution, but escape is not one of them. You must get permission from the warden, and the warden does have a methodology for you to get out of this prison. And that's what I teach in my school. And the warden has said that he'll let you take 5 days off from your work, give you furlough, and you can come to school and I can teach you how to do that. See the tightrope that I walk on? In other words, I can't come in here and tell you people to stop paying your income tax. That's a conspiracy to deprive the government of its revenue. That's a felony. Now, it is true that if you were engaged in private business, you wouldn't owe an income tax. I can teach you the distinction between public and private business, but I can't come in here and tell you people to stop paying your income tax. That's against the law. And especially for those of you that have Social Security numbers and have a contract with this institution. That would be impairing the obligation of contract between you and the institution. I can't come along and tell you to stop performing on your contracts. That's against the law. If you've got a contract, you better fulfill every jot and tittle of it. But the warden has said that I can come in here and talk to you people and that I could lay out certain legal principles to you because it's a matter of free speech. It's a matter of religious free exercise. Now, I can do that. So while I can't tell you to violate the law of Colorado, I can tell you that there's another law that the law of Colorado recognizes under Public Law 97-280, which is called the Law of Moses. So if for some reason you decided you wanted to practice the law of Moses, you could do that under federal statute with the blessing of the warden. Now under that law, it's against the law to pay an income tax. Now we've got a constitutional confrontation. And that's the stuff of which law is made up. It's the exception to the rule. And there's an exception to nearly every rule that comes along. Not every one, but nearly every one. And that's what our school is designed to do, is to teach you those exceptions to the law. Now, we had a question or two back here from this lady over here.
You said that you don't advertise other than word of mouth.
Yes.
Talking to people?
Yes.
Could you advertise in some kind of periodical?
No.
private periodical?
That's why I publish my own newsletter. I can advertise myself in my own newsletter because I don't take any advertising. I'm not engaged in trade, commerce, business, and industry. And perhaps you've seen this litigated where CBS, NBC, or some newspaper will claim that they have freedom of press. Let me tell you, there's no freedom of press in the United States with a commercial newspaper that deals in dollars and takes commercial advertising. Did you notice in my newsletter there's no advertising? I do have freedom of press. But you know, even with the freedom of the press, I don't have a right to scream fire in a crowded theater. So I have to use that within the bounds of the law. So I use freedom of speech and freedom of press very judiciously because there's very precious little of it in the United States. Now, if there's another common law free man around, he and I can have a wonderful conversation. We can talk about nearly anything under the sun. But I have to be careful about what I talk to when I talk to the people here.
Do you have any problem sending anything through the mail?
Yes, you shouldn't send anything to me through the mail that you want to keep private because the government opens all of my mail and listens to all of my telephone conversations. Because you see, it's their postal service.
Can you send
And-
something by UPS then, or what?
Yeah, UPS would be a better way if you want to keep things private, but there's very little left in the way of privacy. Now that only applies to inmates, and of course the government is concerned about me freeing too many inmates, because remember I told you, in 1980, I was a citizen and resident of Idaho, paying about $200,000 a year in taxes. Today I employ no one, pay no taxes, and I'm here to teach you to do the same thing. So I have to be careful about that. You're worth $436,000 to the state and local governments through the course of your lifetime. That's how much you're going to pay in taxes, you know, if you're average. And of course your government doesn't want you to be free from the system because it would free you from those taxes, and of course that's counterproductive to their interest. I'd do the same thing, and I think you would too, if you had a racehorse that was producing $436,000 in stud fees over the life of his career. You'd want to treat that horse pretty carefully, wouldn't you? And you'd want to make sure he didn't escape. You'd make sure that there was no open gates, and that, you know, that you could keep that horse corralled up because he's valuable.
What about crossing state lines with your license plate? You don't have any problem?
Okay, but I'm not a citizen of the United States. I'm an expatriate, and I travel on diplomatic papers. So I'm a different skunk of a different stripe.
What does it mean, expatriate?
It means to voluntarily surrender your citizenship, which means that, and this is a very serious step, I can never become president of the United States. So before you expatriate, you weigh the consequences.
Can they deport you to someplace?
Pardon?
Can they deport you someplace?
Where are you going to deport me to? Neither do they. I was born here. Now, if I'd been born in Canada, they'd know where to deport me. But since I was born here, I'm called a denizen. And I'm just like an Iroquois Indian born on the Iroquois Nation in New York. And you can't deport me.
You don't have a birth certificate.
Isn't it tragic? There's no evidence that I'm alive.
You can't prove where you were born.
Pardon?
You can't prove where you were born.
See? I can't prove where I was born.
Or if you
But wait a minute. Doesn't the government have to prove that I was born someplace other than the United States?
I don't know.
They do. See, the burden of going forward shifts to them. All I have to do is allege that I was born in Fortuna, California. But The burden of proof goes a little further than that. I have to be able to prove it. Yes, I can prove I was born. In fact, it's my government that has the record. I told them to burn it. It ain't my fault if they didn't burn it.
I think that was my question, what happened first, did they have it?
Yeah, they still
We
have
all
it.
have it on record.
Yeah, and they won't destroy it because it's their property. That's what the bottom line is.
When you travel to a foreign country, how do you got a visa?
I travel on my passport.
Do you have that?
Oh, yeah. I'm right here. It's called the Kingdom of Israel. Moses established this kingdom in 1487 BC. It's the oldest continuing existing kingdom on the planet. It's older than the United States. It's even older than England, and there'll always be an England.
Where did you apply for this passport?
When?
Where?
Isabella, Missouri. When?
I mean, you haven't
March
seen all-
5th, 1985. The question I perceive that you want to ask is who issued it? I did. I did. I did. I did.
I think he's asking, when you get over to a foreign country, you go through their customs, what's the problem?
Well, I don't know because I haven't been there, but the Iroquois Indians issue their own passports, as do the Navajos, and they travel all over the world. A passport isn't something that's magical. A passport is a document that identifies your citizenship. It's the prima facie evidence of citizenship. And when I allege that I'm a citizen of the Kingdom of Israel, the burden shifts to the government to prove that I'm not.
Okay, once you're out of the country, you try to get back in, can they stop you from coming back?
Yes.
Then where would you go?
Immigration and naturalization with a show cause hearing. That's my next step. And there's nothing to guarantee that the immigration officer won't pull out his .45, plug me in the chest 4 shots. But if he does, it's wrongful death.
And you still never be president.
And this man says, and I'd still never be president. It's true.
A lot of presidents end up that way.
George, have you seen the letters that they marched this year that Mr. Upton back in New Jersey wrote to the Internal Revenue?
No. No, I haven't seen any letters from a Mr. Upton that I recall. All right. This afternoon, you have one more question?
When did you establish residence in Alabama? Or is it what you mean?
Residency is usually established by a post office box receiving mail. You don't have to buy or rent a house. So you could be a street person living under a freeway overpass. See, a lot of people think, well, gee, I'd have to buy a house or something. Typically, you would live within the physical confines of Alabama, but you know that isn't necessarily correct. For instance, President Bush, where's his residence, by the way?
Texas or Continental?
I don't know. I mean, every time I look at the news, he's somewhere else.
Yeah,
But
Isn't
he runs from Texas. He was elected to office from Texas.
Okay, so, but get this. He spends a lot of time up in Maine. He spends a lot of time in Washington, D.C., and he goes to Texas occasionally. So you see, he probably has established his residence in Texas, and the fact that he travels a lot's irrelevant. Let's suppose that you were a Mayflower driver. Try that. You know, there's a lot of people that travel a lot. And where is the residence? Well, where your post office mailing box is. So just open a P.O. box in Decatur, Alabama. Cost you $10.
A lot of municipalities are asking for proof, they want to see a water bill or a utility bill.
Give them one. Give them one. So what you do then is you have your Reader's Digest sent to your post office box. This is called soft ID. Reader's Digest, Time, Life, Newsweek, and etc. Got any problem with that? Yeah. Where there's a will, there's a way. I see where you're coming from, though. There's a lot of times when somebody will say to you, you can't open a P.O. box or something like that. I'll bet there's 30 people that use my post office box for an address. So if you got a friend down in Alabama, you know anybody in Alabama? Just start getting your mail at that post office box. Just address 10 letters to yourself, and there you are.
What's the advantage of someone like yourself staying in this country, not being a citizen, as opposed to American citizen going to Canada and taking Canadian citizenship?
I missed the question.
What's the advantage of a person like you in your position rather than a person just moving out of the country and taking a...
Oh, going to Canada? Yeah, Canada is a pretty bad place. For instance, the Fourth Amendment doesn't work well up there. The Fifth Amendment doesn't work well. Their judicial process up there, once you're acquitted in Canada by a court, you can be re-prosecuted by an appellate court. There's a lot of reasons why I wouldn't want to go to Canada. They're blood brothers, but they're a little bit off in left field. Same thing with Australia and New Zealand. You know, the socialist governments down there are worse than they are here in the United States. So then there's the guy that comes to me and he says, well then, why don't you go to Russia, you damn communists? Why would I go to Russia when I can practice communism right here in the United States where people speak the same language?
I think that the only thing a passport would get you, which doesn't have much meaning, in foreign countries, if you were arrested in a foreign country, you could go to your counsel.
Well, to answer both your questions over here, let me read to you a little statement that comes from a case. What advantage does it have? The advantage is pretty significant when it comes to the income tax, because the income tax attaches to citizens and residents. And in a case called Rachel Templeton, it was a U.S. versus Rachel Templeton. There it is here. The Fifth Circuit Court, I believe it was, or Seventh Circuit, said, finally we addressed Templeton's second argument in which she claims that she's not a person liable or a taxpayer, as those terms are defined by the Internal Revenue Code and the relevant case law, and as a result that the provisions of Section 6103 do not apply in her case. We agree with the district court that this claim is patently frivolous, as Templeton does not dispute that she is a citizen of the United States, and because the code imposes an income tax on every individual who is a citizen or resident of the United States. So citizenship in the United States imposes a tax duty, and I don't want the tax liability, so that's why I expatriate. Now, I want to caution you that you don't want to use expatriation as the basis for tax avoidance, because it triggers 877C of Title 26, and then the tax can be levied against you for 10 years. The tax advantage has to be collateral to the central issue. Now, I expatriated so I could practice the law of Moses, and the tax benefit is collateral. The reason I pointed that out is that this gentleman said, why don't you move to Canada? If I moved to Canada and became a Canadian, I'd be subject to Canadian taxes. And I don't want to be subject to Canadian taxes or Canadian law. So as an ambassador of the Kingdom of Israel, I'm not subject to either of those countries' law, nor am I subject to the taxes, but I am subject to the law of that kingdom, called the Kingdom of Israel. This is a little more than we have time to get into here today, but it's one of the foundation kingpins of this concept of tax liberation. If you're going to be a citizen and a resident of the United States, then you better make up your mind to pay your taxes to your God, because that's the law. If you don't want to pay the tax, then you're going to have to expatriate. And it's called 14th Amendment expatriation. It's not all that big a deal, but you know, it's fraught with some liabilities. For instance, you know that I can't draw unemployment insurance, welfare, food stamps, public schools, free school lunches. I mean, I've cut myself off from 108 social benefits that are given to me under Social Security. You want to weigh the losses, you know, that you're about to involve yourself in. I can't hold public office. I can't run for public office. I can't vote. I can't work here in the United States. You know, I couldn't get a job at General Electric or Ford. An IRS man asked me one time, he says, well then, how do you live? And I said, very well, thank you. I'll tell you the same thing. I live very well, thank you. I don't have to have income to live. That's a myth. I have increase. Increase is property. Property isn't assessed a tax, never has been.
You don't pay property tax today?
Well, now, property is a different topic. That's an ad valorem tax on building a school in which we have pledged the land as security to Mutual of Omaha as collateral for the bond. It's erroneously called a property tax. It's an ad valorem tax. And it's not property, it's land anyway. Property is a chattel. Land isn't property, it's land. And it's a different legal term, but you know, here again, you look up at the floor and you walk on the ceiling and you pay a property tax. See how preposterous that is? You can't pay a tax on the property because the property doesn't belong to the United States. Take a look at Article 1, Section 4, Clause 17. The United States government is prohibited from owning any land except for docks, forts, arsenals, shipyards, or other needful building. Now, they own Yellowstone Park, but they don't own any of the land that's administered by the BLM or the Department of Agriculture. They're prohibited from owning it, and all the rest of the land's under patent. So they don't own any patented land. So the United States government's very restricted in the amount of land that they own. So they're not charging you a tax on the land. The land belongs to somebody by the name of God, who in Leviticus 25:23 has prohibited the land from being sold. So there's a contested issue of fact as to who owns the land. But everybody's in agreement that the state of Colorado owns it because you pay your rent over here to the Municipal Corporation of Colorado. Now, I still pay the tax on my farm because that farm belongs to Ozark County. But I'm not ignorant as to who owns the land. I know I don't, and I know who does. So I pay the rent. But I think there's a logical methodology for exempting that land from the ad valorem property tax. And we're going to test that probably before the year's over. In a year or two, I'll be able to come back to you and tell you whether or not we can add that to our list. But for right now, I haven't.
How long did it take you to learn all this?
13 years.
In talking about people in the convention here, I heard a number of people talking about suppression by the FDA and other governmental agencies for doing something to people that have misconstrued as healing. And I'm curious if there's any information you could give us, a degree on how a person might sell devices for wicked people or religious food or constitutional food.
That's a good point. His question has to do with this thing of healing and the FDA prohibition against curing cancer and such other diseases. Now, if you go to Exodus 15:26, you'll find that there's a collateral estoppel to you healing anybody. God says that He's your healer. So the state comes along and licenses medical doctors to sell forgiveness of sin. You go to Flo's whorehouse and you get a dose of clap. You go to the medical doctor and the medical doctor says, I've got sulfa drugs and penicillin which will heal you of this venereal disease which you acquired by violating the law that says you shall not commit adultery. So, now that the medical doctor has healed you, he was in violation of the law in Exodus 15:26, for which he needed a license. That's why a medical doctor is a criminal. Now, a lawyer is a criminal by definition. I told a judge this one time. He said, how come you don't have an attorney here? I said, because it's against the law. And he said, well, no, Mr. Gordon, if you don't have the money, I'll have to appoint an attorney. I said, well, I couldn't accept him. It's against the law. He said, oh, that's a novel argument. What do you base that on? And I said, Luke 11:37 through 54. You'd make me an accessory before and after the fact, because an attorney is a criminal by definition. Now, the judge is a lawyer, isn't he? And he said, well, how do you come to that conclusion? I said, well, because they're all licensed. Well, of course, the law requires an attorney to be licensed, which is the prima facie evidence that he's a criminal. And the judge paused and he said, why? Because a license is permission to do that which is otherwise illegal, unlawful, a tort, or trespass. So the lawyer is going to commit a trespass or a tort for which he needs a license to excuse him from the penalty of the crime. He didn't ask me any more questions, but I'll tell you the rest of the answer. When you go out here to heal, you see you're in violation of the common law. Now, you could lay hands on and heal pursuant to the law of Moses. Now, if you did that, you'd be under the Free Exercise Clause of the First Amendment, for which there's a collateral estoppel for government's interference. But you may get struck dead because God might get ticked off at you, but that's the risk you run. Now, when it comes to such diseases as cancer, multiple sclerosis, muscular dystrophy, heart attack, stroke, etc. Those are all copyrighted trade names of the American Medical Association. And they never prosecute you for copyright or trade infringement. They prosecute you for practicing medicine without a license. You're doing something that's a tort or trespass. What's the tort or trespass? Treating cancer. Just like making Coca-Cola. You can't make Coca-Cola and you can't sell it because you got to have a license from the Coca-Cola bottling company because they got a copyright. But I can make Gordon Cola. So where you are over here is that you've got to bring what your activities include under the free exercise clause and outside the scope of the FDA. For instance, in Dallas, Texas, there's a gentleman down there, Dr. Crane, who teaches the subject of alpha biotics. Now he's an old-timey chiropractor. He sent his license back and he no longer practices chiropractic. You understand why? Chiropractic is a copyrighted trademark of the state of Colorado. You got to be licensed to practice chiropractic, but you don't have to be licensed to practice alpha biotic. Now what does this guy do? He grabs a hold of your head and twists it and bends your bones around. Most people would say, well, that's what chiropractors do. Well, that's what this guy does. Well, then he must be a chiropractor. No! He's an alpha bioticist. See the distinction? That's where you've got to be. And if you went to college and you got a degree, those degrees are all badges and identifications of professions which are copyrighted trademarks, like a psychologist, a psychiatrist, an engineer. So you can do those things, but you got to use a different name.
Just don't call it healing.
Now, you can call it healing. Healing isn't a copyrighted trade name. Healing comes from Scripture. It's an English word. I can go out and heal people by laying on hands, but I can't cure or heal cancer. I can heal and treat the scab, the botch of Egypt, but not cancer, multiple sclerosis, or muscular dystrophy. And there's a lot of diseases that are listed in Scripture.
If you put the sale, or I would sell a piece of equipment, is there any way that sale might be protected from suppression and such through some of our convention?
Well, buying and selling are incident to commerce. Why don't you trade or exchange? In the same way that profit and gain are incidents to income. Why don't you deal in property and have increase instead of profit with income? And it's just a matter of words, and those are legal terms. There's about 400 of these legal terms and words that you need to learn. And once you understand this legal language, of which there's not all that much to it, pretty soon you can hold a conversation with a lawyer. It's not all that big a deal. In fact, law is probably the least of the professions. That's why they speak in Latin and use a lot of these 5-syllable words so you don't understand what they're talking about. What they're really saying is that we're really naked. That's all they're telling us.
What's Mexico or South America like to go to? Same problem as with Canada?
I have no idea. I've never been there.
Practical question here. Tell me your license, driver's license. Oh, we're good at travel somewhere. Let's say want to rent a car, and they say, well, where's your license?
That's a good one. I went over to Hawaii one day, and we were staying there at one of those high-rise motels, where the tourists stay on Waikiki Beach. And so my wife said, well, why don't we drive down to the other end of the island? And I said, well, there's a little problem, credit cards, driver's licenses, etc. And she said, I'll take care of that. So she went down to the budget people, and she reserved a Lincoln Town Car for Ambassador Gordon and his wife for 10 a.m. tomorrow morning. So when I walked in, my wife said, this is Ambassador Gordon here to pick up his town car. And so the lady said, well, fill out this form. So I filled out the form. She says, where's your driver's license? I reached in, I pulled out my passport. And on page 3 it says driver's license exemption, but it says it in German. And it says Exodus 23, 32, and 33, and I handed it to her, and she looked at that, and she says, oh, you're from the Middle East. And she wrote down EX233233, closed it up and said, "Where's your credit card?" And I said, "Oh, we don't practice usury and interest in my country. It's against the law to have credit cards." And she says, "Oh, that's right, I did hear something about Muslims that don't practice usury and interest." She said, "Well, let me call my supervisor." So she got on the phone and she said, "Well, I've got an ambassador here, and he's from the Middle East, and they don't have any credit cards in his country." He said, "Oh, in that case, then you're going to have to charge a deposit, $60. So I reached in my purse and I pulled out a Kruger wrench. And I said, "Will this suffice?" And she says, "Oh, no, we've got to have real money."
$500 worth of deposit.
I offered her $400. And so I looked kind of perplexed, and my wife reached in her purse, you know, like there was a bunch of moths coming out. And she pulled out 3 $20 bills. And she held these up, and this lady said, "That's it, that's it." She gave her the 3 20s, and I said, "Strange customs, these Americans." I drove out with their Lincoln Town car with $60 and no driver's license. How's that? Because the bottom line to this is, it's all BS. If you want to rent a car without a credit card, you put a $260 deposit down at Hertz in Tulsa, Oklahoma, they'll give you a card. Now, you do have to have a driver's license or the equivalent thereof, and if you come from Abu Dhabi, Kuwait, or Saudi Arabia, they don't have driver's licensing regimens there. So what would the ambassador from Kuwait do when he comes to Hawaii? He didn't have a driver's license either. He'd give him his passport, which is exactly what I did. So you see, there's a remedy for every cause. Now, if I'd have walked in and said, "Well, I'm from California," and you don't have a California driver's license and a credit card, you don't rent a car. But when you come from the Kingdom of Israel, there's no problem. There's an exception to the rule.
And if you'd had my driver's license, George, you got a 25% discount off there because you've got Kailine Reds.
Okay, so you're traveling on one of these bogus driver's licenses.
Okay, some people who are in the healing profession, don't they have a minister's license or something like that, and just call it spiritual healing?
Well, remember, a license now is permission to do something that's illegal, unlawful, or tort, or trespass. So when a minister comes in and he gets a license, what is it that he needs the license for?
Well, I was thinking protection.
So to do that which is unlawful.
Well, then he wants to break a law, doesn't he?
Yeah.
What law does he want to break?
Wants to be a doctor and homeless.
So doesn't he want to practice religion?
Yeah.
That's what he's doing. Well, did anybody ever explain to you what religion is? See, religion, read, remember, remodel. That's to do something over again. We're going to do over. A lidge. Anybody know what a lidge is? That's Latin for lie. So we want to do over a lie. And ION tells you where. Do you know what the suffix ION means? Among us. So this licensed preacher wants to reiterate a lie among us. And he needs a license to do that. Doesn't he? Because there's a statute that says you shall not bear false witness. And so he's a false witness. Now, he typically doesn't know that because he's not trained in law. The problem with religious people is that they're not trained in law, and the people who are trained in law don't want to practice the law. That's why they need a license to practice law, because they want to break the law. What is it that a lawyer wants to do that he needs a license for?
Just to win at all costs.
He wants to alter, reform, or amend the law. In Deuteronomy 4:2 and 12:32 are a collateral estoppel, where it says that you shall not add or detract from this law so much as one jot or tittle. So the law is already there and it's already complete, and the lawmaker's already made it, and the lawyer wants to alter, reform, or amend it. That's what has always given rise to this concept that no man's property is safe while the legislature is in session. That's the basis of it. They want to alter, reform, or amend the law. Well, it's been good being here this afternoon. Now, tomorrow I have an all-day seminar in which we're going to take up 6 key topics, and I'm going to take an hour on each one of those. We'll start at 9 in the morning and run until noon, and then we'll take off for an hour and a half, and we'll come back and we'll run until about 4:30 tomorrow afternoon, and it'll be a different program tomorrow. And what we're going to do is we're going to take up these various classes that I teach, such as survival and farming. I teach a class on how to make $100,000 on 25 acres or less, which ties in with my survival class, in which I'm going to show you that there are 64 life-threatening problems that all of us face over the next 10 or 15 years. AIDS is one of them. For instance, if you die from AIDS in the next 5 years, you don't need to protect yourself or to prepare for thermonuclear holocaust, do you? Because if you've already died from AIDS, then you've missed your opportunity to die from radioactive fallout, which is another problem that you'll have to survive if you can survive the nuclear blast, and so on down the line. Well, there are 64 of those problems, and what we're going to do is take a look at those classes like civil rights. Has the government thrown you in jail, violated your rights, and do you have a reasonable case? Tomorrow I'll show you what a reasonable case is, and if you don't have a reasonable case, I'll show you how to abscam the bastards, and we'll create one. How's that?
Great.
Which is called abscamming. And I'm good at abscamming. When you haven't got a case against them, you help them create a case that you can prosecute. And that's what civil rights litigation is all about. And we'll take a look at these classes that I teach and how you apply them out on Main Street, and I'll give you some classic examples of how to do that. So for today, it's 5 o'clock. When we break, it's cocktail time, and we'll see you tomorrow morning at 9.